Hi, everyone, and thank you for joining us. This is the ACS policy panel on rescheduling. The Association of Cannabinoid Specialists has been ensuring the highest standards in the practice of cannabinoid medicine, safeguarding patient care with clinical best practices and interfacing with other stakeholders in the cannabis community since 2018. ACS is an international association of healthcare professionals on the forefront of cannabinoid medicine. Founded by cannabis physicians, ACS is uniquely positioned to advocate for the highest standards in the practice of cannabis medicine and safeguard patient care. We're also an advocacy organization striving to provide guidance to lawmakers and regulators at every level of cannabis control, which we'll talk about a lot tonight. ACS is a membership organization, and professional membership is available to anyone, including doctors, nurses, pharmacists, policymakers, lawyers, those in the field of cannabis science, and more. Discounted memberships are available for recent graduates, as well as those living in Latin America and Africa. Student memberships are free for all full-time students and can be acquired by emailing info@cannaspecialist.org. Share my screen here. Can you guys see my screen? Perfect. As I said, professional memberships are available, as are student and discount rates. If you're interested, you can go here at cannaspecialist.org/member_benefits to learn more, or you can email us at info@cannaspecialist.org. Some of the member benefits you'll receive include an annual subscription to cannabis and cannabinoid research, access to a range of clinical handbooks and a curated clinical reference library, 20% discounted pricing on medical cannabis educational courses made by ACS for ACS members and supporters, monthly networking events, and much more. As a reminder, ACS is a nonprofit organization. Events like this one support our mission as we work to educate and advocate for improvements in laws and policies that support patient access and the guided use of cannabis medicine. We hope you will consider donating to our mission so we can continue to bring you the expert panels like this one. You can visit our donation page at cannaspecialist.org/event_donation. Or you can use that hashtag right there to donate here today. Now I'm going to just give you a quick rundown of our cannabis specialists and lawyers who are participating in tonight's panel. Dr. Jordan Tishler is a cannabinoid specialist. He's the founder and president of ACS and a faculty at both Mass General Brigham and Harvard Medical School. He is a national and international keynote speaker and author on a variety of topics related to the medical applications of cannabinoids. He maintains a steady roster of PhD candidates and resident trainees in his clinic, Inhale MD. Dr. Tishler is recipient of Clinician of the Year Award from Americans for Safe Access and the Marfan Society. He is advisor to the Massachusetts Cannabis Control Commission, Massachusetts, Georgia, and Alabama Medical Societies, and board member for Council for Federal Cannabis Regulation, and advisor to Massachusetts Patient Advocacy Alliance, as well as awarded lifetime membership on the Hadassah Physicians Council for his work in cannabinoid medicine. Kristine Blackwood is a health policy consultant in Washington, D.C., representing health policy clients on Capitol Hill. Kristine draws from more than 20 years in leadership positions at the U.S. Department of Health and Human Services and the U.S. Department of Justice, and as senior staff on House and Senate committees with healthcare jurisdiction. Prior to opening her own consulting firm in January 2024, she served as counsel for the public policy practice at Arnold & Porter for 9 years, representing a wide range of healthcare sector clients on Capitol Hill and with the executive branch, including medical societies and health professional association, research organizations, children's hospital, health IT providers, and medical product manufacturers, and advising cannabis industry stakeholders on legislative drafting and strategy. Bryant Godfrey is a partner in the Washington, D.C. office of Foley Hoag and is co-chair of the firm's FDA practice group. He provides strategic regulatory advice to large pharmaceutical, medical device, and biotech companies, startups, and trade associations, helping them to navigate challenges related to the development, manufacturing, approval, and promotion of drugs, biologics, medical devices, and combination products. Having spent nearly a decade at the U.S. Food and Drug Administration in senior regulatory and policy roles, Bryant advises FDA-regulated companies on a broad range of FDA regulatory, policy, compliance, enforcement, and strategic matters. Bryant's experience encompasses a wide range of issues relating to product jurisdiction, medical product development and approval clearance, labeling, advertising and promotion, scientific exchange, investigations of off-label marketing, post-marketing commitments, and requirements. His work also includes current good manufacturing practices, clinical laboratory improvement amendments, compliance, drug supply chain, FDA inspections, recalls, cannabis-derived products, and foods dietary supplements. Mark Bolton serves as head of global public policy for Jazz Pharmaceuticals. In that capacity, Mark oversees all international, federal, and state public policy for Jazz. Before joining Jazz, Mark was a partner at the law firm Brownstein Hyatt Farber Schreck in Denver. Mark also previously served as Senior Deputy Legal Counsel and Director of Marijuana Coordination for Governor John Hickenlooper of Colorado. During his time in the governor's office, Mark administered cannabis policy issues for the state and oversaw the cannabis-related work of 12 state agencies and hundreds of agency employees, and advised numerous other jurisdictions on the national, state, and local levels regarding legalization and regulation of cannabis. You guys are so accomplished, and that was so much to read. But without further ado, I suggest we jump right into the questions for our panelists tonight. The subject of tonight's conversation, again, is rescheduling cannabis from Schedule 1 to Schedule 3 in the Controlled Substance Act, and what that means for patients and their physicians. Any of our panelists can feel free to jump in any time to answer any of the questions. I do ask that the audience keep your microphones muted, and if you do have questions, put them in the chat. We have a full list of questions tonight that I don't think we'll get through all of them. So I don't think we'll get to the ones in the chat, but we can try. So without further ado, let's jump right to those questions. So this is for anyone in the chat, anyone in the panel. What does federal rescheduling of cannabis mean? So explaining the Controlled Substances Act schedules and giving examples of what's in each schedule.
So Kelsey, I can jump in on that. The Controlled Substances Act is basically the comprehensive federal law that was enacted in 1970 that had several purposes. One was to comply with the United States' perceived obligations under certain treaties, but also because it was the fruition of prior years of attempting to control and set up a scheme for drugs and substances that posed serious risk of harm to people, serious risk of addiction, etc. And so there are five schedules in the federal law. The first schedule is the one that basically that cannabis and marijuana currently reside in, and that is, and that schedule is the most restrictive. It basically means that there is no recognized medical use for any substance in Schedule 1, and those substances may not be dispensed or used or manufactured, et cetera, under federal law, as written with certain very stringent restrictions. The drugs that are currently on Schedule 1 include not just marijuana, but heroin, ecstasy, LSD, and interestingly, not fentanyl, except, which is probably the biggest drug problem that the United States faces right now. Fentanyl, in 2018, the DEA rescheduled fentanyl from Schedule 2 to Schedule 1, and for only a temporary period of time, and Congress has basically re-upped that scheduling, which it right now will expire in December of this year. The lowest schedule is Schedule 5. Those are things like cough medicines with codeine, which you'd find behind the counter at a pharmacy in most states. And then, so everything in between. And what we're talking about is obviously the likelihood that we will see a rescheduling of marijuana to Schedule 3.
And just to add on to what Kristine was talking about, with respect to Schedule 1 substances, the Controlled Substances Act prohibits the manufacture, distribution, dispensation, and possession of Schedule 1 substances, except for federal government-approved research studies. And when it comes to rescheduling, it's a formal process. It follows a formal rulemaking process. We know that one was started or kicked off in May of 2024 this year from DOJ, seeking to reschedule cannabis from Schedule 1. And that process essentially is open to the public comments. There's going to be an administrative hearing, and all that has to end before rescheduling takes place. So there's a formality that goes along with rescheduling, but I just wanted to clarify Schedule 1 substances, as most of us know, it's illegal to engage in the manufacture, distribution, dispensation, possession of them at the federal level.
I think I would add to that and say, so what else is in Schedule 3 at this point? And sort of, how did we end up with this idea that we're going to go from 1 to 3 and not 1 to 4, 1 to 5, or off the schedules entirely? Anybody?
So Schedule 3, I think Kristine started to say, includes things like Tylenol with codeine, ketamine, steroids.
Yep, testosterone. So a bunch of medications that are considered sort of mild to moderately dangerous, but useful.
Yeah.
Just for reference, Ativan, right? Lorazepam, benzodiazepines, that's actually Schedule 4. I spent most of this year thinking they were Schedule 3, which makes actually a certain amount of sense to me, but I found out that I was being overly conservative and that in fact they're Schedule 4. So, if we think about the relative values and risks associated with cannabis versus some of these other substances like the benzodiazepines, how do you guys see that we ended up with Schedule 3 as the target for the moment?
Well, I think the Controlled Substances Act certainly sets up a relative analysis. The idea is that substances in Schedule 2 have less potential for abuse than substances in Schedule 1. Those in 3 have less abuse than substances in Schedule 2. Typically, what you have is studies, right, that measure the potential for abuse of a specific formulation of a specific substance that's being considered for control, and it's often compared directly head to head against substances In lower schedules, if you're considering the potential for a Schedule 3 control, you would compare the abuse potential to a Schedule 4 substance and a Schedule 2 substance, and essentially determine how the potential for abuse for the substance in question compares to those others. I think in this context, the evaluation was slightly different, just given the widespread sort of public use of marijuana. In both, sort of state regulated markets and through the history in an illicit market. And there were comparisons made in terms of adverse public health outcomes between marijuana and other substances of abuse, let's say, although it wasn't as controlled as sort of head-to-head comparison in human abuse liability studies or animal abuse liability studies, for example, which would be more typical for the scheduling evaluation of a drug. So it is, I think, to answer your question, Jordan, it's a comparison, a sort of relative comparison to other controlled substances that does determine where on the Schedule 1 through 5 that a substance would fall.
And of interesting note, Wendy in the chat says that synthetic THC like dronabinol is actually on Schedule 3 already.
That's absolutely correct.
Schedule 3 and Schedule 2. I mean, depending on different formulations, one formulation's in Schedule 2, one's in Schedule 3.
Interesting.
Which is interesting in and of itself, but I think we'll leave that one aside. I think one of the points I wanted to kind of get at is that your description, Mark, of how these comparisons should be made and that decision should be put forward should follow that kind of a rational pathway. But I think that in this case, if you look at the totality of the evidence that was presented to HHS, cannabis doesn't really belong in Schedule 3 either. And that this was as far as HHS thought that they could push this. And so I think my point is that there was a little bit of politics involved in this process as well as general science.
Maybe just one other note on this general question before we move on, and maybe it sets up sort of later discussion. I mean, the Controlled Substances Act is intended to set up basically a closed distribution system for controlled substances. And so if you are manufacturing, distributing, prescribing, dispensing, anybody that handles or is in the sort of distribution chain of a Controlled Substances Act, Schedule 1 through Schedule 5, of course, there are different restrictions on the different drugs and substances in different schedules, but everybody's required, if you are doing one of those sort of activities under the Controlled Substances Act, to be a registrant under the Federal Controlled Substances Act and generally under State Controlled Substances Act as well. So to have the requisite DEA registration in order to operate within that closed loop system that the Federal Controlled Substances Act sets up, and the manufacturer has to go through those registered those registrants under the CSA as well. So just the way it functions, I think Kristine set up well, but just to note that it is intended to establish a sort of closed loop distribution system for those controlled substances.
Absolutely, and every 2 years I have to pay $800 to re-register.
Cool. And I would just add, one small point, which is that, as Mark is saying, it's a closed loop system, and it's a way, it's a mechanism for keeping track of inventory and sales, and the only part of that cycle that's not tracked per se, and that doesn't have to register, is the consumer or the patient. But of course, DEA and there are both criminal penalties, and then there's a civil regulatory scheme that a different part of DEA uses to inspect pharmacies, for instance. To sometimes they may crack down on physicians for, if there's doctor shopping or excessive opioid prescriptions and that sort of thing. So, but that could involve not just, it could involve criminal penalties, but sometimes it's basically a regulatory scheme with, corrective actions and a monetary fine, that sort of thing.
In some ways, the consumer is actually in that loop also, right? Through the PDMP system, where, you know, you're not a registrant, but when you purchase your Tylenol #3 or your oxycodone, that is duly noted and available to the feds should they need to review this. So we're tracked at all levels is what this comes down to. Kelsey, what's our next question?
Next question. I'm going to ask Mark this. So what's the difference between descheduling and rescheduling cannabis? And what are the roles of FDA and DEA if cannabis is descheduled versus rescheduled?
Yeah, so Kristine, I think, set this up well. So to reiterate to some extent what she said, the substances in the various schedules of control from 1 to 5 are subject to different sort of rigor in the controls, record keeping controls, importation controls, security controls, and the like, that decrease from substances from between Schedule 1 and Schedule 5. And as I mentioned, the potential for abuse is in theory less for those at the lower or higher end of the schedule, Schedule 5, than those, of course, in Schedule 1. Those that are descheduled typically, you know, there's been a determination that the substance has no serious potential for abuse and therefore doesn't belong in this. It has accepted medical use and you know, if it's an approved drug and an FDA approved drug and does not belong in the schedule of controls because it has relatively low or virtually no potential for abuse. So a Schedule 3 controlled substances, let's just say, for instance, since we're talking about the rescheduling of marijuana, is still subject to DEA control, certain security requirements, importation requirements, not quota requirements, security requirements, various obligations that Kristine pointed out that we're due to uphold pursuant to our obligations under the International Drug Control Treaties of 61 and 71 conventions. So Schedule 3 substances are subject to those different controls. They're less rigorous than those that are subject to Schedule 1 and Schedule 2 substances, but they're still subject to DEA control and oversight. A descheduled substance is not. It's simply not subject to control. It may have been reviewed and evaluated by the DEA and HHS in the course of making a scheduling determination, but once it's descheduled, it's not subject to DEA control any longer. So an example that's relevant for this conversation is hemp, which has now been decontrolled. Any cannabis derivative with no more than 0.3% delta-9 THC is now decontrolled and outside the DEA's control. FDA's jurisdiction doesn't change necessarily depending on the scheduling of the substance. Schedule 1 substances are the exception to that to some extent because those have no accepted medical use and have different sort of research protocol reviews for purposes of research, conducting research with a Schedule 1 substance. But FDA and Bryant can speak to this, and Kristine can probably better than I'm able to regulate substances based on their intended use. And so if the FDA determines that a drug meets its definitions in the Federal Food, Drug, and Cosmetic Act as its definition of a drug, it will regulate it as a drug regardless of whether it's a Schedule 2 substance, 3, 4, 5, or decontrolled. And so FDA jurisdiction of the Federal Food, Drug, and Cosmetic Act to control a substance or to regulate a substance, whether it's as a drug or some other category of product, remains, and FDA will have, remains the way it is today essentially, and FDA would be able to continue enforcing that authority.
It is, I think, confusing to many people in this field that descheduling, taking it out of the Controlled Substances Act, gets the DEA out of the picture, but it doesn't get the FDA out of the picture. And I think that people oftentimes say deschedule when they basically what they want is no real control. And they want to think of it as broccoli, right? So, it's just an agricultural product. Maybe it's controlled by USDA in terms of how it's grown, but that there's really sort of no further control of it as a medication or even as a supplement. And so I think that that's confusing, but clearly that's not what's going to happen. Even if it were descheduled from the CSA, that FDA would still have jurisdiction over cannabis in some fashion. And then the question is, what is that fashion? And that's where we've kind of gotten into this weird position with hemp, which, as you say, has been decontrolled under the CSA, but FDA hasn't really picked that up and regulated because, as they say, there isn't enough to put them through the drug pathway, right? And they clearly don't fit in the supplement and food additive pathway. And so there isn't a rubric. And so there's just kind of been this impasse there.
Great. Moving on to the next question. Bryant, since you're our FDA guy, what's the pathway under the FDA for cannabis to become an approved medication?
So as Mark was speaking about in terms of the definition of a drug under the Federal Food, Drug, and Cosmetic Act, it's a really broad definition. And it basically starts off with like in any article, an article that can be as broad as you want to make it. An article that is intended to like for the diagnosis, cure, mitigation, treatment, blah, 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 of disease in a human, right? So if cannabis is being grown or marketed or sold with claims that, hey, this is for use for glaucoma, this is to help to, your blood sugar, technically meets the definition of a drug. Cosmetic alerts are going on. What we see FDA doing is they, as of early last year, 2023, the agency came out with a statement on their website saying, hey, we are aware that people are using cannabis to treat a variety of conditions. None of that has been submitted to FDA. None of it has been submitted to them to be able to review the safety or efficacy. The drug approval standards require a showing, as Mark was talking about, evidence, clinical studies, of that a drug product will be safe and efficacious for the use for which it is intended. Those clinical trials are drug development in and of itself is a very laborious process, generally about 10 to 15 years. A lot of money goes into them, $500 million up to $4 billion goes into them. So there's a lot of investment before you can kind of go, hey, I'm an FDA approved product to treat this condition. So there's the study part of it. And then there's also, before you even get to the study part of it, there's the investigational part of it. How do you go about actually studying the drug for this intended use that you want to sell it for? Given the current regime, cannabis being a Schedule I substance, it, as Mark said, it's controlled. So even for purposes of research, there's like one NIDA, the NIDA program. You can get cannabis for research purposes, but then also recently DEA has a program whereby which others can manufacture research purposes marijuana for research use as well. So there's kind of two avenues. But essentially, the pathway for cannabis to become an approved medication is going to be the FDA drug pathway. As I said, there's the research angle to that. There's a development angle to that. And as of today, like I said, FDA has not received any information. They are interested in seeing the information. But there's just a lot that's just kind of unknown in terms of even if FDA starts to receive the information from a development standpoint, there's a whole bunch of issues that goes into companies coming forward and how do you parse out IP issues? How do you parse out a lot of different things that remain to be seen at this stage?
I also understand that one of the crucial factors facing cannabis particularly is that the regulations for the phase 3 trials, which are sort of the final large set of trials to prove efficacy in human beings, requires that the drug used in those studies be in its final form, meaning therefore that it can't change if once it's gone through this stage and given approval. And as we all know, cannabis is a plant, and every time you grow some, it's different, right? At least a little bit. So that makes it, as far as I understand it, fairly unlikely that botanical cannabis is going to ever rise to that evidentiary standard. And that it may very well be that we get cannabinoid-based drugs that either come from a cannabis plant like Epidiolex or Sativex, or come from research, that has information and understanding that has been gleaned from the plant material, but ultimately the cannabinoids themselves are manufactured and then combined in some fashion that is fixed and therefore can make it through that FDA crucible.
Jordan, I would just note that I think FDA has made some attempts to try to encourage, even though there's the Schedule 1 status as a really big barrier, but they've issued botanical drug guidance, and they've issued some guidance specifically to research protocols involving cannabis. We've faced this circular firing squad situation for over 50 years, where it just, because of this, the really politically driven scheduling of cannabis in 1970, it's been hard for companies that are interested in developing therapeutic uses for the drug to basically find funding. NIH, to the extent that it's funded research, it's been through NIDA, and it's mostly been focused, to the extent it exists at all, it's been mostly focused on questions like cannabis use disorder or impaired driving, things like that. But the therapeutic potential, there just has not been the traditional market incentives for research. So one of the things that might start to loosen up a little bit with Schedule 3 is that it may become a little easier for some of these companies to explore new therapeutic uses.
And along those lines, I mean, FDA does have even a botanical review team within CDER that is there and available for folks who might be interested in bringing a cannabis or a cannabis-derived product before FDA. But as Kristine says, it's just a new territory for the agency to kind of figure out what this whole development would look like, or approval would look like, if they were to review cannabis on an application, for sure.
I actually looked this up before this, but there are 4 botanical drugs that the FDA has approved for medical indications, it's a drug derived. There's a drug derived from green tea leaves. There's a drug derived from the sap of a South American tree. Extract of birch bark. And then bromelain, which comes from pineapples, and has historically been used for wounds. So there is some precedent, but whether that could be used in the instance of cannabis, or whether, again, there are market incentives for that to occur, is another question.
I have a question for Dr. Tishler. Do you foresee a time when this will be prescribed like regular medicine? And if so, will it become a requirement if it's rescheduled into Schedule 3?
I think that it's very unlikely that we're going to be in a position anytime soon to be writing a prescription for botanical cannabis. I think that one of the interesting things that is potentially to come out of this rescheduling is that cannabis not only is a botanical, but if it's on Schedule 3, it will be unique in that it is the only drug in Schedule 3, and frankly on the other schedules, short of 1, that is not an FDA-approved medication. And so we can write prescriptions for FDA-approved medications. And so if this is on Schedule 3, but it's not approved, and therefore it's not prescribable, the question becomes sort of, what have we gained here? And I will give you my 2 cents on that. I think that a lot of this rescheduling is a very symbolic phenomenon. And I don't want to downplay the importance of the symbolism because, as Kristine pointed out, cannabis and a number of other drugs like LSD and psilocybin were unceremoniously and without evidence shoved into Schedule 1 in 1970 for political reasons. And so the symbolism of getting off of that 50 years later and putting it somewhere else is hugely important, and hopefully will spur a lot of investment in research from the federal government, but also from the private sector, as Kristine was alluding. And I think it will also hopefully open up venture capital investments, et cetera. But in terms of what it's going to do sort of right away, it's not going to really change the practice of cannabinoid medicine, because there won't be a cannabinoid that other than dronabinol, that we can prescribe. So we're going to be left in this similar position to where we have been, where there is federal policy and then there's state policy, and there's a big gap between them. And we as practitioners are going to have to continue to navigate that on behalf of our patients. There also will likely be some tax benefits to moving from Schedule 1 to Schedule 3. Personally, as a physician, that thrills me a whole lot less than some of the other potential benefits. But I think I will let our esteemed lawyer colleagues talk about that aspect of things. And if you guys want to jump in on 280E?
I agree with everything Jordan said. I don't think you can prescribe. I mean, like we talked about the CSA before, it's a closed loop sort of distribution system. So the product has to come from a DEA registrant. And at least as of now, not that this isn't subject to change, but as of now, companies that operate in state medical or recreational cannabis programs are not DEA registered. And so the idea that you could write a prescription, which is an order for those products when they are coming from outside the closed loop system, I think is unlikely. I don't see DEA changing their position on that. And I totally agree with you on 280. I think 280 is pretty cut and dried in the statutes. It applies to the trafficking of substances in Schedule 1 and Schedule 2. So if the DOJ direction is ultimately adopted, it lands in Schedule 3. That statute would no longer be applicable, and the disallowance of sort of what we think of as typical business deductions would no longer apply to for purposes of federal income tax, corporate income tax for those companies.
Mark, I had it put to me, and I really don't know what the reality here is, but it was said to me at one point that maybe the 280E would still apply because the companies that would want to write them off are still not in compliance because they're state legal and not federally legal. Do you think that that's accurate? I mean, could the IRS maintain that position?
So let me just preface this by saying I'm not a tax lawyer, and nor am I anyone's lawyer on this call. But my understanding is, and Bryant and Kristine may who are also fabulous lawyers, would maybe a little opine on this too. But I think it's a statutory issue where it just applies. Section 280 of the tax code just applies to trafficking in Schedule 1 and Schedule 2 substances. It doesn't have to do with illegality under the Federal Controlled Substances Act. Certainly if you are a registrant and you are trafficking in those substances lawfully under the Controlled Substances Act, you would not be in violation. But the fact that it doesn't even apply to a Schedule 3 substance, I think, would protect those businesses from that imposition of that provision of the law.
That's great. That's good news.
Um,
Yeah, go ahead.
I should add, I've since leaving my law firm, I've gone on inactive status as a lawyer, so I'm not practicing as a lawyer, and I focus on policy, healthcare policy. But I would say that the IRS. I mean, the IRS is one of the least political animals in the federal government. But I think they're going to be pretty straightforward about interpreting 260E. And but bottom line is, if I'm running a cannabis company, I'm going to consult my accountant because before submitting a tax return with a lot of business expense deductions. So, and I suspect that most accountants are going to encourage their clients to take the tax deductions and test whether, I mean, there's no implementation there's no regulation or anything that, well, I could be wrong about that. The IRS might have to amend its regulations, but I don't think it's an automatic sort of statutory category. You're either selling or distributing a Schedule 1 or Schedule 2 substance and subject to 280, or you're not. So it should be pretty straightforward. Yeah, and IRS is going to miss that money. Making a lot of money.
I said I wasn't going to ask anything from the chat, but I really feel like this is just important to get, just the vibe from you guys. Do you think that rescheduling is going to open up educational opportunities for people both in becoming lawyers and clinicians? Are they going to be introducing classes? More. There's no educational opportunities. They don't teach about the endocannabinoid system in medical school. I'm sure they don't really touch upon cannabis when you go to school to become a lawyer. But do you think there'll be more educational opportunities about it, with rescheduling in the picture?
I can speak to the medical school that I know, which is, as you all know, one of the most conservative and bass-ackwards in the universe. And I can tell you that they have, over the last few years, brought in more education about the endocannabinoid system at the molecular level. And they've had more discussion about cannabis use disorder than previous. And frankly, I think that those are positive advances. But what they are unwilling to do at this point is really entertain the therapeutic use for human beings. And as far as I can tell, that has nothing to do with the state of the evidence, because it would be perfectly reasonable for them to teach a course or to integrate this material into courses in which they say, well, here's what we know and here's what we don't know, right? I mean, that's a perfectly legitimate academic discussion, but at this point, not even willing to sort of have the here's what we know discussion. Will Schedule 3 change that? I think to the extent that universities are often driven by their attorneys, this may change sort of the appetite for this discussion. But because it isn't going to move into a prescribable category, it's not going to have that kind of practical effect, right? I mean, it's not going to be like, okay, you're going to be graduating from your medical school, and this is going to be a drug that you need to know how to use because you can't write a prescription for. I personally would argue that that's even more reason that we need this education in these settings, to some degree in medical school, but absolutely at the residency level. And I've certainly spent a lot of my time campaigning for that, but it's just hard to move that needle in these large and very conservative organizations. And I don't know that Schedule 3 is gonna really the thing that tips that.
I would just chime in. I couldn't agree more, Jordan. But the one thing that will be different now is that the federal government, the Health and Human Services Department, will have recognized that there is commonly accepted medical use federal policy, what they do, in Washington, D.C., does not necessarily translate into immediate culture change um, or educate people. I mean, for instance, for 2 years now, the Feinstein bill, the cannabis research bill, has been on the books, and that actually codified the Ninth Circuit's injunction that was issued years ago, permanent nationwide injunction, basically saying that the federal government cannot interfere with a doctor-patient relationship and the ability of a doctor to recommend and discuss the use of cannabis for therapeutic or any other purpose. And yet, that's not what really changed things. I mean, I think it comes from, it comes slowly with anything.
Mhm.
Yeah, I think you're absolutely right. It's a culture shift. Let me take a moment to have a little shameless plug here. We're as an ACS, as an organization, we're about to release, we're thinking October 1st, a brand new CME activity. It will be, to the best of my knowledge, the first CME of its kind in the United States that is actually AMA approved for and accredited for credit, which is different from other, just general educational activities. And I think that our being able to get that through is a testament to these advances, the sort of incremental advances. But it's also, why are we doing this? We're doing this because we acknowledge that medical professionals, physicians, and everybody else are not getting this kind of education where they ought to be. And so we need to provide it outside of or in addition to their regular curricula. So
Yes, there are other
more to come on that.
there are other cannabis programs that are CME, but this is definitely the most up to date. And it is obviously made by the Association of Cannabinoid Specialists, whereas the other ones aren't really made by specialist groups. So it's definitely has the most focus, and we're really excited about it. Not to go off on a tangent about how excited I am about that program, but it is definitely relevant. So my next question, I don't really know who to ask this to. I guess all of you. Will rescheduling encourage insurance companies to cover medical consultations and the cannabis products themselves? And Jordan, I know you have probably a lot to say on that.
Yeah, so I'm going to keep my mouth shut and let everyone else. How about starting with Mark, because he has a lot to say about that too.
Yeah, there may be. I think there'll be an interesting sort of spectrum of opinions on this. My hunch is no, it won't change things dramatically. The evidence, I think insurance companies are interested in seeing adequate, well-controlled clinical trials evaluating a specific formulation and a specific dosing in a specific patient population, and then that ultimately leading to FDA approval of a drug. So they're going to be heavily indexed towards the evidence that demonstrates substantial safety and efficacy, as Brian spoke about earlier, for purposes of a new drug application. I don't that we obviously, as discussed tonight, don't have that evidence. I think the evidence that supported the HHS evaluation is all evidence that's been in systematic reviews and been in the sort of body of evidence for a meaningful period of time. HHS found currently accepted medical use in 3 different indications, 2 of which there's FDA approved indications for synthetic THC. So they would be covering dronabinol or nabilone in those indications. The third one is pain, and I just don't know that the evidence would be strong enough. I can't say with any expert authority that it would or wouldn't be. But my hunch is that it wouldn't be without an FDA approval. It wouldn't be sufficient evidence for them to cover it. I also think, as we talked about, that this doesn't change the legal status of medical cannabis operators under the Federal Controlled Substances Act. It changes the status of cannabis from Schedule 1 to Schedule 3, but not the legality of those operators or those products. And so I think between the legal considerations and implications for a carrier and the sort of evidentiary considerations, my hunch is this won't be a sea change in the way payers view reimbursement of the product. I think in a lot of instances, insurance companies are already covering the consultation with a doctor, but I'll defer to Jordan on that.
So, so basically, I completely agree with everything you said. And what I have seen is that, insurance in our country is a whole bunch of individual companies, right? And then we've got the federal government that does Medicare, and that really influences the way everybody thinks. So if Medicare turns around and says, we're going to cover this in some fashion, then it's likely that the other private insurers will start to do that as well. What I have found is that Medicare will not cover the consultations, but a number of private insurers will, typically at the out-of-network reimbursement, assuming that you have coverage that allows out-of-network. So if you have only in-network, then you're out of luck. So it's very complicated, and we provide the documentation in my clinic for everybody to submit for reimbursement, and many patients get some money back, but it's not all the money and it's not every patient. And a lot of what we're used to in our current medical reimbursement scheme is that we as a patient don't have to interact with the insurance company, right? The doctor's office or the hospital files a claim with the insurer, and then there's a payment that goes between them. And there are a number of reasons why that's good. There are a number of reasons why that's bad. But it all presupposes that the clinicians in particular have signed up as what's called a preferred provider with that insurance company. And that's part of the way those insurance companies make sure that they control their costs in those providers. But you can't do that with Schedule 1, with cannabis in Schedule 1, right? They're not going to accept me onto their roles of preferred providers where I deal specifically with cannabinoid medicine. And so at this point, yes, some of my patients are getting reimbursed, but it's through their efforts to communicate directly with the insurer, and that presents its own sets of problems. So bottom line is, I think that things might improve in some degree. And actually, really where I think it might improve is that many years ago, insurance companies would not cover certain alternative things like therapeutic massage, chiropractic, acupuncture. And what we saw happen in the late 90s, early 2000s was insurance companies to compete with each other started to cover some of these alternative medical approaches. And so I can definitely see that there might be enterprising insurance companies that might say, yeah, you know what, Medicare is not covering this, but if we cover this, then we can say, look, we cover your medical cannabis, come to us as an insured. And I think that may be a stepping stone to sort of broader insurance coverage overall.
Great, thank you for that. So I think we can fit in one last question for tonight. And I think it's a very important one. It was actually sent in by one of our ACS advisory board members. And maybe Kristine or Bryant could touch on this. Will rescheduling allow patients access to cannabis as medicine while in rehabilitation facilities, or if they're hospitalized or incarcerated? I know a lot of patients don't have access to their medicine, currently. So we're wondering if rescheduling will allow them access to that. And it's a really hard question, I know.
Well, I think sort of along the lines of what we've been saying throughout is that the state regulated programs are going to remain pretty much unchanged. And so if I mean, federal prison being, probably the exception, but if you're in a rehab program or and you are otherwise allowed to have access to your cannabinoid medicine, you should be able to continue. I mean, remember, there's less criminal liability on the federal level with lowering the schedule level here. But there's also a whole scheme in place to keep the DEA out of the state compliant medical marijuana systems. So the patients should be able to continue accessing. That's just my take on the answer to the question, but I defer to Bryant and Jordan and Mark.
And do you think it'll allow more patients access, or do you think it'll allow patients access because it's been rescheduled, or just it'll continue to be the same as it is?
I think it's going to be a matter of what your state allows.
Yeah.
I don't think the rescheduling will have an effect on that. I don't know. I could be off base.
One area where it may be interesting. So California, Massachusetts, et cetera, a few of the states have said that institutions like rehabs can avail themselves of their state medical programs. And basically what we've seen is nothing, right? Meaning they can, but they don't. And some of that is that cultural conservatism, but I think some of that is the concern that, yeah, maybe legal and protected under the state law, but we are a large medical institution, get our money mostly through Medicare. So we really have fears about what could happen to our federal sources of funding if we avail ourselves of these opportunities under the state law. And in California, they went so far as to go from you can do this to passing what's called Ryan's Law, which says you must do this. And I don't know how successful Ryan's Law has been in coercing these rehabs or other medical institutions into behaving. But I think that if it's no longer Schedule 1 and it's Schedule 3, even though that really doesn't change anything in that legal structure, it may change things in the minds of those administrators who are trying to weigh their options with regard to federal versus state opportunities. It gets back to that cultural shift, really, more than anything else.
Great. Thank you. There are so many questions that we didn't have time for tonight. A lot of that same thing where it's, it's down to the states, it's down to, states versus federal. But, I really appreciate you guys coming on and talking to me and answering our questions. There was a lot of great chat questions tonight. I'm sorry we couldn't get to them all. But yes, thank you, Mark, Kristine, Bryant, Jordan, for everything. Thank you for supporting ACS. I'm going to put our website into the chat right now. So if you'd like to check it out, become a member. And I'll put our email in as well. So that way, if you are a student or have any questions, you can email me. And we appreciate you for joining us tonight. And we'll see you soon. Thank you so much.
Thanks, everybody.
Thank you.